So welcome everyone. And before I start with the proper introduction, please note that this event will be recorded. We will make the presentation available online, but not the discussion. So after the presentation, feel free to ask your questions, and we will start the recording now. Welcome to the launch event of the Bonavero Report, the absolute prohibition of refoulement and exceptional circumstances. This event is co-hosted by the Bonavero Institute for Human Rights at the University of Oxford and the Chair for Public Law and Human Rights at the University of Münster. My name is Marlene Stiller, and I will be chairing this panel, and I will also provide a brief introduction into the context of this report. But before I do this, let me first extend a particularly warm welcome to our speakers for today. We have Başak Çağlar, who's a professor of international law at the University of Oxford and head of research at the Bonavero Institute of Human Rights. Then there is Nora Markard. She was the chair of public law and human rights at the University of Münster and coordinated the third-party intervention documented in this report. A warm welcome to James Hathaway, who's the Deakin Professor of Law Emeritus at the University of Michigan, and to Joyce de Koning. She is a Max Weber Fellow at the European University Institute and an adjunct professor of EU law at the NYU Law School. This Bonavero report reproduces a third-party intervention by the Chair for Public Law and Human Rights and 22 academics, including our speakers and myself. It concerns legal questions arising in the context of pushbacks in exceptional circumstances. Pushbacks are measures by which states summarily force people on the move back to another country without access to an asylum procedure or an individual assessment. In the last decade, they have become a common practice at Europeans' land and sea borders. Since 2015, EU member states have increasingly been justifying pushback practices with hybrid attacks, implying a warlike situation. This rationale is used for situations in which third countries, such as Belarus, Russia, or Turkey, facilitate the movement of migrants to the EU external borders in order to exert political pressure on the EU. In a recent communication, the EU Commission has actively supported the view that fundamental rights may be restricted in response to so-called hybrid threats. This Bonavero report challenges these political views. It aims to provide an authoritative statement of what the international law on non-refoulement obligations requires from states, even in exceptional circumstances. The third-party intervention that this report documents was submitted in the case of C.O.C.G versus Lithuania. This case is currently pending at the European Court of Human Rights, along with two similar cases, HMM and others versus Latvia, and RA and others versus Poland. In all three cases, applicants for international protection were forced back onto Belarusian territory without being given the possibility to apply for international protection and without an individual assessment. These three cases will be heard by the Grand Chamber on the 12th of February 2025, only a week from this event, which makes today's discussion all the more relevant. A prohibition of refoulement is contained not only in the European Convention on Human Rights, but also in the 1951 Refugee Convention, in the Convention Against Torture, the ICCPR, and other international treaties. All of these prohibitions are absolute. This means that pushbacks that amount to refoulement cannot be justified. The report therefore examines whether exceptional circumstances, in particular purported instrumentalization of migrants as hybrid threats, can modify states' obligations under international law and, in particular, the absolute prohibition of refoulement. In the following 20 minutes, our speakers will analyze four legal regimes which are relevant to the interpretation of non-refoulement in situations of hybrid threats. So, Nora Markard will first outline the exceptions recognized in general international law, including necessity. James Hathaway will then lay out the exceptions regime of the 1951 Refugee Convention. Başak Çağlar will talk about the derogation regime of the European Convention of Human Rights. And finally, Joyce de Koning will address the exceptions provided in EU law including the new crisis regulation. With this, I now hand over to our first speaker, Nora Markard. Thank you.
Thank you, Marlene. So in general international law, it is recognized that in exceptional circumstances, states may not need to fully comply with all of their obligations. And there are three exceptions that are recognized in customary international law and that have been laid down also in the Articles on State Responsibility. First, force majeure, two, distress, and three, necessity. The first two exceptions, force majeure and distress, do not apply here. This is because force majeure only covers situations where the state literally has no choice of means. So where there is an absolute and material impossibility of complying with the obligation. Now, in our case, states have many alternatives to refoulement, for example, calling for international solidarity. The second exception, distress, only applies in a situation where there is a threat to the life of the duty holder or of a person entrusted to her. And this is much too individualized and much too concrete to justify pushbacks in our context. This leaves us with necessity. And necessity exists when there is a grave and imminent peril for the essential interests of the state. So to its existence, to its political or economic survival, to the continued functioning of its essential services, or to the maintenance of internal peace. This is not a very high threshold, so this exception may very well apply here. But there are several other conditions that would prevent states like Lithuania, Latvia, or Poland from relying on this exception for breaches of their non-refoulement obligation because of a purported instrumentalization of migrants for so-called hybrid attacks. The first of these conditions is that the breach of the obligation must be the only available means to address the situation. It's not enough that it is just less costly or more convenient than alternative measures. Now, as I mentioned, a request for solidarity is always an alternative to refoulement, and so are accelerated procedures or, of course, increased spending. Secondly, the breach must not seriously impair an essential interest of other state parties or of the international community as a whole. This community as a whole phrase refers to obligations erga omnes, which, according to the International Court of Justice in Barcelona Traction, includes basic human rights. That means that reliance on necessity requires a balancing of the state's interests and of basic human rights. So in the case of pushbacks, because of the strong protection for non-refoulement, it would be very difficult to argue that, in the words of the International Law Commission, the state's interests really outweigh all other considerations. The strength of this protection of non-refoulement also plays a role in the third condition. The state cannot rely on necessity for breaches of an obligation that excludes the possibility of invoking necessity. In our case, non-refoulement is contained in the European Convention on Human Rights or in the Convention Against Torture, the ICCPR, is an absolute obligation that is also non-derogable. This clear intention that no exceptions should apply means that a recourse to the general defense of necessity would be arbitrary. Necessity is definitely excluded if one considers non-refoulement part of jus cogens. And finally, it's called general international law because these are the rules that apply when there are no special rules. And when an international legal regime has its own set of rules on exceptions, the lex specialis principle applies, and the special rules displace the general rules. And so necessity does not apply where and to the extent that there are lex specialis rules. And indeed, the ECHR does contain such special rules in its Article 15. My colleague Başak Çağlar will say more about this in a minute. Here, it is enough to say that Article 15 ECHR allows states to derogate from some of their human rights obligations in exceptional situations, where there is a war or another public emergency threatening the life of the nation. So Article 15 ECHR, and the same goes for Article 4 ICCPR, it deals with the same subject matter as necessity, meaning that it is lex specialis. But Article 15 ECHR also contains more stringent requirements, both substantive and procedural. So if states could also simply rely on necessity, this would seriously undermine the limiting purpose of Article 15. Therefore, reliance on necessity is out when it comes to human rights non-refoulement, meaning that necessity cannot justify pushbacks. Thank you. And I'll hand it over to James Hathaway.
Hi. So my task is to speak a bit about the grandfather regime, the International Refugee Convention of 1951. And I really just want to make 2 points. The first is that non-refoulement as a concept was invented in the 1930s in the refugee regimes precisely to deal with the kind of situation that these cases raise. In earlier refugee regimes, there had only been a duty of non-expulsion. But it was noticed that certain European states were using informal rejection at the border as a way of avoiding their duty of non-expulsion. And so the 1930s refugee conventions added a duty of non-refoulement precisely to make clear that this sort of informal rejection at the border that Lithuania, Poland, and others have engaged in is prohibited. So it couldn't be more clear on the historical record that this falls afoul of the prohibition. The second key point is that in refugee law, it would not be accurate, in my view, to speak about this as being an absolute prohibition. And I actually think that's a good thing, to be slightly controversial. I think absolute prohibitions give rise to bad conduct by states. They try to get around the regime. The refugee regime actually does have 2 exceptions. But my second and critical point is that neither of these exceptions applies. It is impossible for either to be invoked in this circumstance. First of all, both of them require that there be an assessment of a concern with a refugee. In other words, an individuated assessment. That has not happened in this case. The first situation dealing with final conviction of a serious crime and danger to the community clearly isn't relevant. The second possibility of informal rejection of a person who is shown to be a danger to the security of state might be arguable. But when one looks at the jurisprudence, not only does it require an individuated assessment, but there has to be, said the Supreme Court of New Zealand, objective evidence, said the Canadian Supreme Court, clear and convincing evidence, said the Supreme Court of the United Kingdom, credible and strong evidence that meets a demanding hurdle. None of these has even been tested, much less proved in these cases. As the Canadian Supreme Court made clear in Suresh, there has to be a vital national interest at stake. And this is the really critical part. It has to be shown in line with what Professor Markard has said about the principle of necessity. The Court of Justice of the European Union in the HT case, 2015, said it has to be clear that there is, quote, no other measure possible or sufficient, unquote. That's inbuilt into whatever exceptions refugee law might allow. So the bottom line is that the idea of an exception to refugees' duty of non-refoulement because of a so-called hybrid attack is a non-starter. Number one, there's no particularized assessment. Number two, the demanding evidentiary hurdle has not even been tested, much less met. And number three, there's been no showing that less intrusive measures would not suffice. So on refugee law, this is an open and shut, easy, slam dunk no.
All right, so let me come back to the ECHR and the exceptions regime, or as we call it, the derogation regime of the ECHR under Article 15 that Nora has mentioned is the regime where states can temporarily suspend some of their obligations under the convention. So let me do three things. First, just to tell you a little bit about how this regime operates, and then ask the question about whether obligations under Article 3 ECHR, where the non-refoulement obligation flows in the context of the convention, how it engages with it, and maybe briefly on also Article 4, Protocol 4, which prohibits collective expulsions. So Article 15 has a regime that has developed also through the case law of the European Court of Human Rights since the 1960s. And we understand this body of case law, I think, through 5 cumulative conditions about when states temporarily can derogate from some of their obligations under the convention. The first rule, which is, I think, very, very important, is that states can only derogate from their derogable obligations. This creates a regime of derogable versus non-derogable rights. And this is also mirrored in the ICCPR. So this is not something very specific to the ECHR. Now, the second is if a state is able to derogate from their derogable obligations, they have to meet the principle of necessity, which means that there must be war or other public emergency threatening the life of the nation. And what we know from the case law is that the necessity requirement is a very unique place where the court has recognized, the European Court of Human Rights has recognized that this may be subject to the margin of appreciation in the sense that the state will know better whether there's these kinds of threatening circumstances. The third of the cumulative conditions is that whatever the measures that's taken through law, through policy, or through practice must be strictly required by the exigencies of these highly threatening situation, threatening the life of the nation. And fourth requirement is that these derogations must also be compatible with other obligations that the states have under international law, be it under public international law, refugee law, other human rights law obligations. So there has to be a coherency. And finally, there's a procedural obligation that one has to inform the Council of Europe Secretary General about what is happening and what is the rationale of the derogation and so on and so forth. So this is cumulative the regime, but what we have also seen in the case law of the European Court of Human Rights are some couple of very important case law-based observations where the court has very clearly said that states should not be abusing the derogation regime. They shouldn't be using this regime to circumvent their obligations under the convention, and they shouldn't be derogating to undermine the rights that are protected in the convention. And this flow also from the case law. Now, coming to the prohibition of refoulement under Article 3 ECHR, which is unique from what James said, because we don't have the word non-refoulement in the convention, but this has been interpreted seminally through the Soring versus United Kingdom and lots of other cases, that the prohibition of torture, inhuman and degrading treatment must be understood to incorporate the prohibition of non-refoulement, that any person has the right to have an assessment of whether they may face a risk to their lives, to their bodily integrity, and so on. So this is why prohibition is absolute, because it comes under Article 3 prohibitions when we talk about it in the ECHR. This means that I think from the 5 cumulative tests, you will already see that it doesn't meet the first and absolutely the first condition where you can only derogate from derogable rights. So if non-refoulement's procedural obligations that individuals have the right to be able to assess, there has to be an assessment of their risks of life and bodily integrity, risk of torture, inhuman, degrading treatment, it just collapses on the first test, I would say. So we don't have to maybe go through, of the other tests. And I think this is an important point that the court has also reiterated in its case law on Article 3 when states wanted to push back on the absolute nature of procedural and substantive obligations that flow from Article 3. Now, there is an important question, and I think next week's hearings and the court's case law, the European Court's case law, may develop in important directions. And this has to do with whether this regime could justify derogations from Article 4, Protocol 4, which prohibits collective expulsions. Now, This provision says all collective expulsions are prohibited. So it sounds like a non-derogable prohibition to me. It reads like one. It doesn't make a list of situations where this may or may not meet the criteria. But it's important to note that the court has never said that in its case law. So it hasn't made that pronouncement. But I think there are some very important reasons that the third-party intervention also outlines to develop the court's case law, perhaps in that direction. But our aim is to state the current case law. So let me just say two sentences about this. The prohibition of collective expulsion, as James has really significantly underlined, is a really intrinsic link with the prohibition of refoulement. So these two are not separate sort of rights or prohibitions, but they have an intrinsic relationship. So if a state is permitted to derogate, which I don't think they can, from this obviously has significant impacts also on the prohibition of refoulement. So this is the relationship between two is, I think, an absolutely crucial aspect where I hope the court will also develop its principled case law. And finally, this link has already been underlined by other United Nations treaty body organs, in particular the Committee Against Torture in its general comment on non-refoulement, which also ties us back to how we interpret the convention and its provisions. And particularly under the derogations regime, there's an explicit emphasis that this regime cannot be understood in isolation from states' obligations, which in the case of the Council of Europe, the Convention Against Torture is an absolute clear obligation for all member states of the Council of Europe.
Then moving to European Union law, the key takeaway that I'll be giving you for today concerning EU law is that it does not allow for wholesale derogations from non-refoulement, collective expulsion, or international protection. But with that in mind, one needs to be wary of the exceptions to the exceptions under EU law moving forward. So under EU primary law, that is to say the EU's foundational treaties, two grounds for limiting such rights can be found in the chapter that governs the EU's area of freedom of security and justice. Now, those two derogations under primary law are found in Article 72 of the Treaty on the Functioning of the European Union and Article 78.3 of the TFEU. Article 72 merely reaffirms that the member states of the European Union remain responsible and retain the prerogative to ensure the maintenance of law and internal security as a counterweight to the fact that there are no more internal borders within and between the EU member states. Article 78.3 of the TFEU spells out the procedure to be followed in cases of emergency that are characterized by mass influx of individuals. And under this procedure, EU provisional measures may be adopted to accommodate such situations, albeit subject to certain conditions. Now, what's probably more interesting for today's conversation is the recently adopted crisis regulation, which is secondary legislation within the EU's framework. And this crisis regulation, which will come into force on the 1st of July 2026, has been received skeptically, understandably, as it seeks to clarify what to do in times of crises and force majeure and how to provide an adequate response to that type of hybrid threat that it spells out. Now, it defines crisis as an exceptional circumstance of mass influx of such a nature that it jeopardizes the internal functioning of an asylum system. And it additionally identifies crisis as a situation of instrumentalization. So this really captures what has been going on at the EU's borders as of late. And then it identifies or defines force majeure as unforeseeable circumstances which prevent member states from complying with their respective obligations under EU legislation on borders, asylum, and migration. Now, specifically, when we look at the limitations that the secondary legislation foresees, we see that the limitations are actually quite procedural in nature and go more to the point of the time limits for the procedures to lodge international protection requests and the extension of time limits with respect to the border procedure. But again, these are more of a procedural in nature, and they do not affect the essence of the right to ask for asylum, for international protection, and they definitely do not affect the essence of the non-refoulement obligation. But as I hinted at, there are conditions to apply to these exceptional situations. And the case law by the Court of Justice clarifies that in order to be able to invoke such limitations to the rights, this does not actually give member states free rein. It is not a general derogation clause, and it must be interpreted strictly, cannot impair the essence of the rights at stake, and can only impact the procedural components thereof. In addition to that, the member states remain bound by the principle of sincere cooperation. So when relying on one of these exceptional grounds, they would have to be complying with that obligation in not just their implementation of EU law within this specific domain, but more generally also their obligations under EU fundamental rights law. And that brings me to the third condition to be able to rely on such limitations, namely that there must be respect for fundamental rights law. So if we go back to primary law as well as secondary law, which spell out these limitations to rights such as non-refoulement, collective expulsion, and international protection, we see that these are all blanket caveated by the fact that both EU member states and EU institutions, or EU entities rather, would have to remain compliant with fundamental rights law. And so what fundamental rights law means under EU law becomes extremely important. We see that fundamental rights law under EU law refers to the Charter, first and foremost, the Charter of Fundamental Rights, as well as general principles of EU law. But more importantly, maybe for this particular session, is that indirectly, by virtue of Article 52.3 of the Charter of Fundamental Rights, the ECTHR and the ECHR regime become directly relevant for the EU's understanding of fundamental rights, because this article spells out quite explicitly that for corresponding rights that we find in the Charter of Fundamental Rights that are also found in the European Convention of Human Rights, the minimum level of protection that applies will be that of the Convention of Human Rights and the complementing case law. That means that the Strasbourg Court understanding of the non-refoulement principle, collective expulsion, will be the standard that applies under EU law. Now, I said at the start that this would be a talk about the conditions to the conditions and the exceptions to the exceptions. And this is precisely the issue that we're left with under EU law. Even though we have that minimum level of protection that prevails when we're talking about non-refoulement or collective expulsion, this is then caveated by the fact that the minimum level of protection under EU law will only apply insofar that this does not negatively affect the autonomy, the primacy, and the unity of EU law. And thus, with this new crisis regulation coming into play, one unresolved question is how that will be interpreted, mindful of the effectiveness of EU law, the autonomy of EU law. And that remains something to keep an eye on as we move forward. What all of this means for the member states that are bound by the Charter of Fundamental Rights as they apply the crisis regulation and EU primary law is that they remain subject to full review by the Strasbourg Court in implementing their EU obligations and their EU rights. This because they retain discretion in applying the crisis regulation, and they retain discretion in applying more generally EU law on borders, asylum, and migration. And because they retain that discretion, they are subject by virtue of the Bosphorus Doctrine to the review of the Strasbourg Court. Thank you.
Yes, thank you very much for this valuable input. And we will now open it up for questions. I will just quickly say goodbye to those of you who are watching the recorded launch event, as this marks the end of the recording. And you can find the full report on the website of the Bonavero Institute under the title, The Absolute Prohibition of Refoulement and Exceptional Circumstances. So thank you for watching. And now we will continue to the round of questions.